Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, attorney and doctor Steve Hendler walks through the unique context of a physician employment agreement. So, let's tear it down. Hey everybody, welcome back to the Contract Teardown Show from Law Insider. I'm Mike Whalen. I am here with my friend Steve Hendler. Steve, how are you doing today?
I'm doing great, Mike. How are you doing?
I'm good. You and I were talking before we started recording about the proliferation of billboards in the Kansas City metro area of lawyers who are also doctors. You're one of those, which brings us to an interesting document, this physician employment agreement. We've talked about employment agreements before. I'm showing this to the folks at home. This is a specific context. When are we going to see this kind of document, Steve?
So this is becoming more and more common. Just to put it in context, there are about 1 million physicians in the United States. About 40 to 50,000 new physicians come out of training each year. And last year, 80% of the physicians coming out of training became employees. So we're seeing more and more traditional employment contracts as opposed to employment contracts that are designed to move into partnership ownership agreements. So healthcare is 20% of the economy. 50,000 physicians a year, 40 to 50,000 new contracts a year. So it's become more commonplace.
Yeah, a busy space, and it's a highly regulated industry, which is why I love this as a specific context. So we're going to dig into this document. You're going to give me some insights on what you're seeing here in terms of how this was drafted. I'm actually going to start with the end. This is relevant for lawyers too. I see people trying to buy each other's practices, and what can you sell? In Texas, all you could buy was unexpired leases and equipment. That transition is actually really interesting. So let's start with the end in mind. In 7.7, it talks about the termination of the relationship. It says upon the expiration or termination of the employment pursuant to this agreement, physicians shall a bunch of stuff that they're supposed to do, get rid of, documents, give us the keys back, those kinds of things. And then some things that the practice is supposed to do. What are you seeing in 7.7? What do you like? What do you not like?
Well, I think the general obligations are clearly delineated in terms of what the physician needs to do. A lot of it is, for lack of a better term, boilerplate. That is, these are things any employee would be expected to do. You turn in the keys, as you said. You turn over any records. You go through the exit process as necessary. There is a clause that obligates the physician to do whatever is necessary to transition patient care. And again, that's a major, you mentioned the regulatory issue. That's a major regulatory obligation of state medical boards, is making sure that patients don't get abandoned. Medical boards are there to preserve and advocate patient safety in the medical environment. What it doesn't do, and this is sort of a new thing in the world of employment, is say what the employer's obligation is to facilitate the physician's regulatory obligation to meet these needs. That is, the physician, many states have specific regulatory requirements of what a physician must do upon leaving a practice. It doesn't indicate that the physician is obviated from those obligations because he's an employee, and somewhere in the contract it might say that these patients belong to the practice. That's an interesting issue related to the Corporate Practice of Medicine Acts, which differ in each state. But physicians are reporting that when they're leaving a job, they're having difficulty getting their employer to comply or allow them to comply. So, for example, some states, there's a requirement that you notify each patient individually. Well, physicians don't have access to those patient lists. And elsewhere in the contract, it pretty much says physicians don't have permission to act as an agent. And this one actually has an agency clause in it somewhere. So what happens is there's this gray zone of what happens when the employer does not make the facilities or make the steps possible for the physician. And so the answer should be that there should be a clause that the employer is responsible for facilitating and meeting either the state's requirements, or in states that don't have requirements, the AMA has some recommendations as to what should be done in those transitions. So that sort of leaves the physician in this gray zone and dependent upon an employer who is acting properly.
Well, let's jump to the duties of the actual doctor. This is under 2.4 titled Other Duties. The other stuff, physician shall perform such administrative and other duties and functions incidental and related to her duties and assist practice as requested by practice with administrative duties which are relevant to the services and necessary for the ongoing operation of the practice. I've seen articles, I actually wrote in Lawyer Forward about a study out of Harvard about these doctors who were being pulled to and fro to these administrative duties, and it was hurting the quality of care to be spread out in that way. What do you think about how this is drafted in terms of what power the practice has to tell the doctor, hey, you got to do this stuff whether you like it or not?
Okay, so the drafting gives the practice complete power, and that may or may not be reasonable, although I don't think it's reasonable. The real issue is there's nothing in exchange for that complete power. Now, this contract, interestingly, calls for a flat salary. There's no bonus structure. There's no productivity standard. Most newer contracts are coming out with either a true pay for performance, pay for productivity compensation plan, or some kind of bonus structure. So if you add, 10 hours a month of meetings and other obligations without compensating for it, what you're doing is taking 10 hours a month. That's, out of 150 or 180 hours, that's 5 to 10% of the physician's time. And I can tell you that a lot of these obligations take much more. The other interesting thing about it is that it allows the practice to determine essentially what's within the purview of the obligations. So one issue that has become a hot button is how do you manage the issue of physicians managing non-physician practitioners like nurse practitioners and physician assistants who create a liability for the physician. The physicians ultimately become liable for the acts of those non-physician practitioners with whom they're collaborating, also take time, and they create billing and revenue, but the billing and revenue frequently is not going to the physician, even though they're being left with the liability and the loss of time to produce. So this is, those things I think need to be more clearly spelled out, and certainly as a lawyer who tends to function more representing physicians than employers, I would advise my clients that these are the things you need to know about. What you decide is right for you is your decision, but you should know and you should have some clear sense up front how the employer is going to address those issues should they make these assignments to you.
Yeah, because as you pointed out earlier, as a physician, you have a professional responsibility, not just for yourself, but in the structure of supervising. Like that's why they have licensed supervisors, is so that, somebody other than the PA or the nurse practitioner, that they're taking that liability. There's somebody to sue, right? Similar with lawyers. It's a fascinating issue. Let's jump to the term. Very short. It says the term of this agreement shall begin on the effective date, which if you look back at the top, the effective date is the date that they signed this agreement, and continue for a period of 3 years unless earlier terminated as provided herein. What do you think about this term description? What's missing?
Well, a couple of things. The most important thing is that this sentence is extremely clear. I mean, there's no ambiguity. The challenge and what's become ambiguous is what are the conditions for starting? And what we're seeing is so again, prior to starting the actual work as a practicing physician, there's a period of licensing and credentialing both with the hospital and with insurance companies. So the licensing is not something within the hospital's control, and usually the applicant, if they're already licensed in that state, it's a non-issue, obviously. But if they're applying for a license, it may take several months. And the applicant does have to get paperwork into the hospital quickly so that the credentialing process, both for internal practice and privileging and for reimbursement from insurance carriers, can begin. The challenge is that hospitals historically have been rather laconic about this process. It can take literally months from the time they receive all of the documentation that they need to get the process going to the time final approval comes. So if the applicant has all that paperwork in, say, 3 months ahead, the hospital still may have a month or 2 months of necessary time to get that paperwork completed. And some hospitals are saying, well, if you don't have the credentials to practice, we're not starting you and we're not paying you. And so for these physicians coming out of residency and fellowship, these are not physicians who tend to have a lot of actual resources. So it puts them in a very difficult situation, and it gives the hospital really no incentive to actually. So when I say it takes 3 to 6 months, it doesn't have to. It does because that's how the processes play out, and there's never been an incentive to say, okay, we really need with this physician starting in 90 days, we have all the paperwork, we need everything in place so that on day one of the effective date, they can actually start. And then the other thing we're seeing is more and more orientation requirements that come either through the hospital's own internal assessment or through some of those regulatory agencies that demonstrate that the physician has had proper training in using the electronic medical record, that have had proper orientation to harassment and the Stark anti-kickback and self-referral laws, et cetera. And those things can take, up to a week of time that a lot of the employers are saying, well, you need to come and get that done before you can actually start. And when you think about it, anyone who's ever had a job almost anywhere, when you are an employee and you have to come in for orientation, the employer pays for orientation. But the expectation frequently has become you're not starting until you've been oriented to the position. So to my point of view, those are things that could be made clear, especially in the context of how things have evolved in the physician employment space.
Yeah, especially if what you're doing is making sure that people are properly trained. You want to give space to that. And with that, I want to jump to 4 because I'm sensing a theme in this document, which is that, the employer here is trying to have it both ways of putting off responsibility to be a professional on the doctor, but maybe creating some policies that make that harder. I'm going to read a bit of this benefit. It says, in addition to physicians' compensation, practice shall pay premiums due to maintain physicians' medical malpractice insurance coverage for the services. Fine. Practice shall, at its sole discretion, determine the carrier, the amount of coverage, and all other matters related to medical malpractice insurance. That's putting a lot of power back in the practice while putting that professional responsibility on the doctor. What do you think about that benefit?
So let me start just as a general preface and say it's sort of an unusual concept that physicians are among the only employed individuals in the United States where coverage for liability on the clock in the scope of work is not a given. So a nurse gets employed by a hospital. There's never a question that if the nurse is named in a lawsuit, the hospital is going to take on responsibility for defending the nurse. So because that's industry standard, we sort of accept that. That part I get. And the issue of who determines the malpractice carrier, I don't have a real issue with that either. What concerns me is the next part, that they not only can determine the carrier, they can determine the amount of coverage and all other matters. Now, what's interesting, even more so to me, is the next sentence in that paragraph talks about other fringe benefits. And then there's a general concept in the final sentence that the practice retains the right to terminate or alter in its sole and absolute discretion any benefit plans or policies at any time. So if I'm representing the physician, I'm going to say this is a problem because, they can come after you personally if you've got $200,000 per incident of malpractice coverage, because that's what the practice provided. It's pretty hard to shield assets down to that level. And so you may have some personal liability between $200,000 and a judgment or settlement. That's A. B, a lot of states have minimums. This doesn't address what the minimum is or whether they will necessarily meet state standards. And finally, the other interesting thing about the medical malpractice space is there's been a shift, although there's no consensus as to whether the standard is that an employer or a practice will provide occurrence-based insurance or claims-made insurance. And again, occurrence-based means, just to refresh everyone, that the coverage is in effect if the action arises from an occurrence that occurred during the coverage period. Claims made means that the coverage is in effect if the incident occurred during the claims coverage period and the plaintiff brought the action during the claims coverage period. So with the statute of limitations, particularly, this happens to be a fertility practice where there are pregnant women, we hope, because that's the idea in a fertility practice, but things can still go wrong, and where the doctor may be liable not only for the doctor has two patients, and one of whom is an infant, which means there's a statute of limitations that tolls for 18 years. So there may be no coverage, and this doesn't specify. And I think that's important. And if I'm representing the employer, I'm going to say, you wrote this contract. It's ambiguous. There's no industry standard. If something happens, this under the canons of construction, this is going to be ruled against you because it could be interpreted in any number of ways, including this issue of that last sentence. Are they talking about the health policies can be canceled at any time, or are they talking about any policy in this paragraph? I think this is not only very imbalanced, but also I don't think it serves the employer at all. I don't think it serves either party the way it's written. And again, I think honestly, malpractice insurance and professional liability insurance is so important in a physician contract. I would actually separate it from anything else in the contract so that there is absolutely no question what anything in that term or provision or paragraph applies to.
Yeah, well, and on the theme for our last section, on the theme of these are independent professionals in some ways, but they got a job in other ways. Let's jump to time off. Physicians shall be entitled to paid time off for vacation and sick leave. It has a bit in here that practices consent to physicians' request to use PTO shall not be unreasonably withheld, but then doesn't give anything about what unreasonably means. What do you think about how this is drafted? How would you talk to doctors about making decisions around that clause?
Well, I'm going to, if I could, share a personal experience. When I was in practice, I was employed by a hospital, and they actually came to me and said, you've got a lot of banked PTO. We have a use it or lose it policy. And I said, okay, my use it, lose it period ends in 2 months. I have 3 weeks of paid time off. I'm taking 3 weeks off next month. And they came to me like hair on fire. Well, we don't have a physician to cover for you. And I'm like, well, I'm sorry, that's not in my contract. It doesn't say my contract obligates me to have coverage. Now, they were willing to add a rider to my contract that indicated that in situations where we were unable to secure proper coverage for patient care, that the use it or lose it provision would be waived or deferred for some specified period of time that could be renewed. So we resolved it. But the problem here is, you're right, what's unreasonable? Is unreasonable that, well, hey, we're going to lose a lot of revenue if you leave? Or is unreasonable, hey, there's 38 patients in the hospital, we don't have another doctor, we're not willing to explore getting a locums tenens physician? Is unreasonable, hey, there was an earthquake that has cut off communication with the outside world? I mean, I think it's incredibly vague and ambiguous. And again, it puts all the onus on the physician, partially because we have to do this, but also because we have that professional fiduciary obligation. Being employed does not relieve us of our fiduciary duty to the patient or relieve us of our patient-physician relationship. And so this, to me, that's a problem for this way, the way that this scheduled time off provision is written.
Yeah, and you're seeing this pattern of this weird context of you're an individual with professional responsibilities, but you've got this job. I have a bit of a weird question for you in closing. We talked initially about all the billboards in Kansas City with I'm both a doctor and a lawyer, and it always seemed a little gimmicky to me. I mean, maybe it works for the sake of personal injury so you can understand, but it seemed like a bit of a gimmick. In your case, here's somebody you are a lawyer and you deeply understand the context. And what I hear all the time from businesses is it drives me crazy that my lawyer doesn't understand my business. I'm going to ask you to get maybe a little meta and tell me, how has your background as a physician made you a better lawyer for physicians? How has that context knowledge served you as a counselor, advisor, advocate?
That's a great question, Mike. So I'm going to share another anecdote. I was at a law society social event recently here in Kansas City, and I was telling a young lawyer who's probably been out of school for 5 to 10 years that I had an interest in working with physicians, and I got a somewhat blank look from him, and I said, "Gee, have you ever had a physician client?" And his response to me was, "Yes." And I said, "Well, how did that go?" He said, "Well, let me put it this way." He said, "If my next physician client is only half as difficult, they'll still be my 2 most difficult clients ever." And I don't want to say all lawyers feel that way. I do not believe all lawyers feel that way, but I do believe that I joke and tell people I'm bilingual. I speak lawyer and doctor. And when I'm working with clients, and sometimes they'll say, "Well, my malpractice carrier's attorney said this, that, or the other thing to me." And I don't do malpractice litigation work, but I do meet with clients in the role of general counsel to discuss what's going on. And I can hear that when that conversation took place, there clearly was there was something in the translation that did not make it to the physician. And so to the degree that I can hear what a physician's saying and I can feel it and see it, I think that does give me some advantage and allow me to get to places with a physician in their thinking and in their understanding of a legal process or a claim or a contract, why something that seems so ridiculous or so small or unimportant is actually very important or very not ridiculous, or this will have a huge impact on a jury if the case is going to trial, for example. So I think the advantage I bring is that I've worn that hat. When a physician tells me about something that happened to them that involves a legal or regulatory process, I'm sitting there thinking, I know exactly how you feel, and some of them are so raw that when they describe it, it's like reliving it. And so by sharing that, yes, I understand exactly what you're saying. That's a tough point, or that's a terrific point to be in, and here's why. I think allows the process to move forward a little more readily because there's some degree of comfort that I'm not just giving lip service.
Yeah, and I don't think anybody's saying if you're going to go be general counsel for a trucking company, you need to go to Georgia Tech and get a master's degree in supply chain management. But the big complaint that we all get is that you don't understand the business. So I would simply suggest that when you go to bed at night, the books around your bedside table not only be books about contract construction, but maybe about construction or whatever industry you're in. It's always helpful to know the context, and you see the problems in documents like this that other people just won't catch. So I appreciate you bringing this to us, Steve. For people who want to learn more about your practice and about how you meld these worlds in this interesting way, what's the best way to connect with you?
Oh, my website is probably the best way, www.mmlawkc.com, and I'm happy to talk with anyone anytime about physician contracts or any other interesting aspect of the law.
Great. We'll have that contact information and this contract up over at lawinsider.com/resources where you can find them. And if you want to be a guest on the Contract Teardown Show, just email me. I'm at community@lawinsider.com. We would love to have you. Steve, thank you again for joining us, and we will see you all next time.
Thank you, Mike.
Thanks so much for tuning in to this episode of the Contract Teardown Show from Law Insider. If you're enjoying the show, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. That helps others find the show. We really appreciate it. Thanks again for listening, and we'll catch you in the next episode.